Right, well, good evening, ladies and handful of gentlemen. It's a pleasure to be with you here tonight. And before we start, I'd like to begin by acknowledging the Turrbal and Jagera peoples as the traditional owners of the land on which we're meeting in person. On behalf of UQ Law School and the Trust Ethics and Governance Alliance of UQ Business School, I pay our respects to the elders past, present and emerging. We recognise their contributions to Australian and international society and the painful legacy that land and wage theft has had on them and their ancestral communities. Statistics on modern slavery are appalling. According to a recent UN and NGO report, there are almost 5 million people in situations of modern slavery every day. That translates to 1 in every 150 people in the world and includes too many children and many people in our region. The Modern Slavery Act 2018 is the cornerstone of Australia's response to modern slavery risk in corporate supply chains. It's a reporting regime and it applies to large entities, both public and private, as well as to slavery risks that arise in Australia and internationally. The scope and the ambition of the Modern Slavery Act seems to show that Australia is, as it were, doing its bit to address this terrible problem. But there are challenges in implementing the standards, both for organisations and for the people that seek to hold those corporate actors to account. My name is Radha Ivory, and I'm a senior lecturer in the UQ Law School. Tonight, I'm joined by an illustrious panel of specialists to discuss these challenges and opportunities in their global context. I start with Dr. Joseph Lelliott, my colleague in the law school, who's a senior lecturer and expert in trafficking of persons and migrant smuggling. Joseph has written extensively on these topics and is currently co-editing a commentary on the Organised Crime Convention of the UN for Oxford University Press. Dr. Anfal Berkish is lecturer in law at the University of Liverpool, where he researches public international law and international human rights law. His specialty is third state complicity, and he's visiting UQ right now to carry out a project that applies those insights to modern slavery regulations. Ms. Louise Hope, in the middle, leads the procurement and payment services function at UQ. She has a background in the legal and insurance industries and has delivered UQ's programs on modern slavery risks and the engagement of Indigenous suppliers. Dr. Erin O'Brien is Associate Professor in Politics and Policy in the School of Justice at the Queensland University of Technology. She also happens to be a graduate of UQ. She is currently an AIC DECRA Fellow, her DECRA Fellowship exploring the framing of responsibility for modern slavery between state, civil society, and market actors. Last but by no means least is Professor Thomas Mak. He is the inaugural professorial chair in ethics at the UQ Business School. Thomas is a global authority in the field of responsible leadership, business ethics, and the micro foundations of corporate social responsibility. He has previously held senior roles in the area of leadership at the University of Melbourne. Welcome to you all, and to you all, whether you're joining us in person, as we're delighted to see people here tonight, or online. We'll begin, Joseph, with a question to you. When we talk about modern slavery, we're obviously talking about serious forms of labour exploitation. But what does modern slavery actually mean? And how does it differ from other forms of exploitation, like human trafficking? Where does the idea that Australia even has a legal obligation to combat modern slavery come from?
Hopefully this is well. Yeah, it's definitely working. Okay, well, good evening, or I guess late afternoon, people in the room, and also to those online. And thanks for the question, Radha. So I'll kind of come to, I guess, the two parts of your question, sort of one after the other. So the first, I guess, thing you asked was, well, really, what does modern slavery mean? And that kind of brings me to what is perhaps a bit of an initial challenge in this space. And this is obviously called challenges and opportunities. So first challenge. So this is because it's a little difficult to really say what modern slavery precisely means, at least in a way that is consistent across jurisdictions. Modern slavery, for example, in Australia's National Federal Act is defined with reference to other terms. So treaties and criminal provisions, for example, offences in the Commonwealth Criminal Code, rather than receiving sort of a definition in and of itself. The same goes for modern slavery in the comparable UK Act, which includes modern slavery in the title, but refers more to other more technical concepts such as trafficking and slavery. The issue here really is that when it comes to modern slavery, there's no sort of concrete definition of modern slavery in international law. It doesn't have a specific international legal definition or a framework attendant to that. It's really more of an umbrella term, and I think it grew more principally out of advocacy efforts in this space, and probably kind of a desire to have more of a shorthand term that would encapsulate a range of quite technical and quite diverse practices, exploitative practices. So while it certainly encompasses labor exploitation, and that's something you mentioned specifically, it is also much broader than that. So you mentioned human trafficking and how, for example, modern slavery and human trafficking are different from each other. And perhaps this is an area where things are a little bit difficult because modern slavery is quite a broad, sort of, in some ways, perhaps nebulous term, whereas trafficking has a very specific, concrete international legal definition. So modern slavery definitely includes trafficking, but it also includes, or is usually construed as including slavery, slavery-like practices, forced labor, etc. If we take human trafficking, which has more of a concrete definition, then trafficking sort of is put simply actions taken by one person against another, broadly with the purpose of exploitation. And modern slavery kind of maps quite closely onto that sort of idea of exploitation as the crux of it. Indeed, much of what we would now probably call or think of as being modern slavery, if not all of it, probably as well, would be trafficking and vice versa. Modern slavery is perhaps just more the in vogue term in that way. So just before I come to the second part of your question concerning international legal obligations, it's worth noting that the use of the term modern slavery is not sort of only, I guess, at least in my opinion, an issue of semantics. At a conceptual level, the sort of breadth of the term means that it includes things, I would say, that aren't really perhaps the focus of the Modern Slavery Act in some senses, such as sexual servitude, forced marriage, etc. These are obviously not things that would generally be considered supply chain issues or the kinds of things that entities would be reported on. Is that much of an issue in practice? Perhaps not. I know that the recent report following the review into the Modern Slavery Act noted some definitional issues, but didn't go into too much sort of, I guess, detail on it. But what could perhaps be said is that a lack of a consistent international legal definition of modern slavery does perhaps have some implications for sort of consistent transnational understandings of what the term means, purely because in different national laws, it's going to be defined according to how that national legal system defines it. For example, other countries aren't going to refer to Australia's Commonwealth Criminal Code when they're defining modern slavery. So what is modern slavery in one place could potentially, in a very strict legal sense, look quite different to how it looks in another. I note that a few of the submissions to the recent review, for example, one by the Australian Human Rights Commission, suggested that Australia try to pursue more of an international consistent legal definition of modern slavery as one kind of recommendation in this space. The degree to which that is feasible, it seems probably quite unlikely, but I guess it's a nice idea in some senses. Okay, just on the second part of your question, where does the sort of legal obligation derive from? So, because I'm referencing a few treaties, I have some notes so I don't miss anything. So really reiterating what I was saying just before, there's no international, I guess, treaty that specifically prohibits or otherwise addresses modern slavery in a really explicit way. What we sort of really rather have are a range of international instruments that ask Australia to prevent, combat various quite explicitly defined phenomena, things such as trafficking in persons, forced labor, slavery, and we have various international instruments that deal specifically with these, the Anti-Slavery Convention, the ILO Forced Labor Conventions and its attendant protocol from 2014, the Trafficking in Persons Protocol, which supplements the UN Convention on Transnational Organized Crime. So to different extents, these instruments also place obligations on Australia and the other states that are party to them to protect victims of these various crimes also. Do these treaties, however, place my water there? Sorry. it's gone. It doesn't matter. Do these treaties, however, specifically ask Australia to set up a reporting scheme in the specific sense of the Modern Slavery Act? Not really, though the MSA could be seen as going towards Australia's general prevention obligations under these instruments. For example, Article 9 of the Trafficking in Persons Protocol asks states to take all measures as necessary to prevent trafficking, and something like an MSA can be seen as going towards that particular obligation. That question of international obligation does bring me to my last point, however, and I think I'm still on time, hopefully. And that's another area potentially of challenge and opportunity also. I'm talking here with the recognition that this has been addressed, this idea of due diligence in the recent review. So my comments, I guess, hopefully align with a little bit of what's very recently been said on this. But the current sort of fairly voluntary and non-enforceable nature of the Modern Slavery Act does arguably quite little in meeting Australia's related obligations to protect human rights, including through specifically regulating business and their supply chains. So while the MSA has been, I think, quite arguably a positive development as sort of a first initial regulatory step, and it's sort of increased awareness of modern slavery. It's definitely prompted some businesses to arguably change their practices and take steps towards that in terms of how they do things. The degree to which it's made a tangible difference in this space is perhaps somewhat unclear, and a lot of the research around it indicates that also. So one of the focus areas of the recent review into the Act is concerned the potential for more concrete due diligence requirements. And that's something we're seeing emerge in the field of human rights generally in a number of other jurisdictions, particularly in Europe, say France, Germany, etc. So numerous submissions to the review, which is sort of recently concluded, suggested there be a more sort of concrete due diligence requirement consistent with the UN Guiding Principles on Business and Human Rights. And while this would obviously present a more onerous set of obligations on reporting entities, and that in its own way would be challenging, it could also be seen as an opportunity to bring Australia more in line with some of its obligations under international human rights law. So hopefully that answers both of your questions, and that'll bring me to the end.
Joseph, that was a wonderful answer and a great way to kick off the rest of our discussion. With that, I'm going to turn to Antal, and we're passing the microphone along, and also the questions about really what a good national human rights regime in this space looks like. So Joseph Antal has alluded to the definitional problems around modern slavery and suggested that this divergence might be a part of the difficulties in comparing or aligning national standards in this space. So we presume that there are variations in how states are implementing modern slavery or their desire to combat modern slavery. In your work, how are you characterizing these various national approaches, and where does Australia's Modern Slavery Act and regime fit within those approaches that you're seeing?
Thank you, Rada. I will continue where Joseph just stopped. So we see that in this tendency from 2010, when we have a line of development of international soft law regulation on business and human rights, there are dozens of states who have adopted regulation on modern slavery and corporations, including Australia. Within those development of various domestic laws, we can see two regulatory models. The one is a trade ban. This is, and an example is the United States Uyghur Forced Labor Prevention Act of 2021, another, the European Commission's recent proposal of trade forced labor regulations. The US Act presumes that any product coming from the Uyghur regions of China is produced through forced labor, and any importing company may rebut this presumption. Whereas in Europe, the presumption is the contrary. There is a presumed absence of forced labor, and any member state authorities have to investigate once there is a risk of an economic operator violated the ban. Various other states, including Australia, however, pursue the second model, which is a corporate due diligence model. Here, the domestic regulation obliges business corporations to eliminate modern slavery from their activities. Examples include chronologically California, the UK, Australia, France, the Netherlands, Norway, Germany, Switzerland, and 2 weeks ago, Canada also enacted such a corporate due diligence act. The fundamental difference between those two regulatory models is that when a domestic law adopts a policy of trade ban or boycott or disengagement, the law's main addressee are governmental institutions who have to control and enforce the trade ban. When the law obliges the market actors to eliminate modern slavery from their own activities, this is a policy of engagement by governmental institutions, non-governmental organizations, and business enterprises. The idea behind is that eliminating modern slavery from global economy supposes and requires the coordinated action of all stakeholders, including state, federal, regional authorities, but also corporations and the well-informed consumers. There are remarkable similarities and differences between those different domestic laws on corporate due diligence, but I will just mention 3 main points or questions. The first is what kind of harm, especially what kind of labor exploitation the given domestic law addresses. The second, which are the actors or corporations obliged by the law? And third, what are the activities, especially in the global supply chains, which the domestic law intends to eliminate? Where the intends to eliminate labor exploitation. So first question, what kind of harm, especially labor exploitation, the domestic law targets? And here the domestic laws indeed presents major varieties. The first due diligence law, the California legislation, only focused on slavery and human trafficking without even defining them. However, as the UK and Australia, as Joseph explained, included a quite comprehensive long list and definitions of slavery-related practices. The French and German laws, however, go even further and are more ambitious in the sense that they oblige corporations to eliminate any violation of human rights, violations of human health, security, and the environment. This legislative choice is crucial because if the harm is defined very broadly, then the corporations must eliminate harms that might be too burdensome for them, even hinder economic activities, and might be unrealistic to implement. A too narrowly defined harm might, however, give green light to certain forms of labor exploitation in global supply chains. A second question, which are the corporations obliged? And here again, there are variations in the domestic laws on corporate due diligence. The first three adopted such laws, the Californian, the UK, and the Australian Modern Slavery Acts, define a certain monetary threshold of gross turnover of the corporation, ranging between 44 to 100 million US dollars. So mainly corporations over this minimum threshold of monetary annual turnout will have to be obliged by the law. The French and German laws, however, oblige corporations above a certain threshold of employees, number of employees, 3,000 for French, 5,000 for French, 3,000 for the German corporations, or the Norwegian law, which combines these minimum thresholds of employees and minimum income. Another extremity, the Dutch law obliges all companies which provide services and products to Dutch consumers, no matter their size, no matter their state of incorporation. However, the burden on corporations might seem here less burdensome because this law only targets child labor and not other forms of harm. And third question, what are the activities, especially in global supply chains, that the domestic law aims to eliminate? Here, this is a difficult question because corporations might not be able and willing to assess the risk and eliminate the risk of modern slavery from their partners' activities, especially in global supply chains when the production or services cross state borders. Chronologically, again, the first such act, the California legislation, only required corporations to assess the risk from their direct partners, so from the direct supply chain, meaning the tier 1 suppliers, whereas all the others, the UK, Australian, and the later due diligence acts, focus sometimes explicitly, like the Australian act, on corporations with direct and indirect suppliers. So suppliers with tier 2 and lower end of the supply chain. So these are differences do not necessarily in some translate into differences in effectiveness, but everything depends on very much on the implementation efforts, the implementation capacity of the state, and the compliance by corporations. So in sum, what is certainly a global trend to eliminate modern slavery is to focus on forced labor and child labor as a minimum threshold, to oblige larger corporations who are in the capacity to effectively control their partners, and to extend this risk to all the entire supply chain, to both direct and indirect suppliers. Thank you so much for your attention.
Thank you so much, Antal. You've done a wonderful job of painting a picture of great complexity in this area. So while the basic principle might seem to be something that everyone can agree on, the way that countries have actually gone about implementing that is extremely different. Within all of that regulatory model, if we want to call it that, we have Louise, who has the job of actually implementing the Modern Slavery Act's reporting regime, in itself a very complex and large public sector organisation, namely the University of Queensland. Louise, could we ask you to share your reflections on the challenges and the opportunities of Australia's Modern Slavery Act for achieving an uplift in this area of governance?
Thanks, Rada. I can. This is so fascinating because we have probably approached this challenge in a more direct, certainly less intellectual way than my companions on the floor here on the panel. And so when we first were asked to take ownership of the university's response to modern slavery, and I'm saying we in this bit, and in a little while it'll be absolutely me, because I'll be saying some things that are not the university's views and only mine. And the university views and position on modern slavery can be found in our 3 public statements that are on the Border Force website and on our own website. But what we did is really looked at the legislation and decided it had 2 key objectives. The first one being preventing modern slavery from occurring in the first place, and then remediation, putting the actual victim back into the position they were before the harm was incurred. Actually, for us, the reporting is nothing but a byproduct of the work we do to think about the individual in this problem. And it's an analysis of an individual that I think summarises the problem and the challenge we have in the university. And that's what I'm wearing today. So I thought very carefully about what I was going to wear to this seminar. So I chose a dress that is made by an organisation in Sydney called the Social Outfitters. They teach migrant women, pay them a living wage to design and manufacture clothing. My shoes are from an Australian manufacturer of footwear that has very publicly accessible information about the factories they use overseas to manufacture their footwear, and there are other social enterprise undertakings, charities they support. I have no idea how my stockings are made. I have no idea how my other smalls are made. Can't remember when I bought my earrings. Makeup, maybe one of them is from Byron Bay from a holiday, but the rest of it, who knows? And so that's kind of the problem the university faces as well. We can think about a couple of big ticket obvious items, but a university like the University of Queensland is fundamentally devolved in its decision-making to start with. And we buy every single good or service you can possibly imagine. I would challenge you to think of something this university does not purchase, because I've seen it all, including rockets and radioactive materials. And there's not much in between that we don't buy. So that's fundamentally our challenge, but it's also our opportunity. And in my view, it's also the challenge with the Modern Slavery Act regime in Australia. So just to touch on some specifics, because we've focused, and when I say we, I talk about the Modern Slavery Working Group, which is a cross-functional group. That's how I know Joseph. He's our sole academic now, trying desperately to get more. Because the other thing I wanted to point out is that the Australian Modern Slavery Act goes beyond requiring us to think about our supply chain, or as it's now going to be known, the supply network, by the looks of it, but it asks us to think about our operations. So it actually does want us to go beyond the obvious. And so our work has thought about students going on placements. That's not part of our supply chain. We think about how the risks associated with a piece of field work in a developing nation, where we get a collaborative arrangement with another university in another country. And by some miracle, we get 3 seasons of data collected for $10,000. How is that happening? And so that has been a real challenge, moving away from just supply chain. I can understand that. That's my day job. It's the operations bit, I think, is actually super challenging and hard to see. And that complexity is really our major challenge. But what we've thought about and what we've really focused on is engagement and awareness. And so really fundamental grassroots, posters being printed, training being developed, not mandated, because we all know at a university it's hard to mandate anything, but we're developing online training that's super accessible, just to help people understand. We're conducting an annual survey to try and measure awareness. And then we're doing a whole lot of sort of underneath work around improving our data visibility, understanding how we actually take that data and analyse it and filter it to understand which of our suppliers are in fact high-risk suppliers. Are they in a high-risk jurisdiction? And we're doing some really interesting and exciting work with the other Australian universities who are part of the Australian University Procurement Network. And that is just an amazing collaborative piece of work, all driven by the professional staff of the universities, which has been very rewarding and I think impactful, has certainly driven a lot of understanding. One of the other challenges in the regime and the reporting requirements in the Modern Slavery Act is around supply compliance monitoring. And, you know, one looks at advice available at how you go about that, and it will talk about, you know, asking detailed questions of your suppliers, conducting audits or on-the-ground assessments, or indeed inspections. But really only the first of these, asking detailed questions, is something that's truly feasible without significant expertise and resourcing. I can tell you right now, there is no way that this university will pay me to go and visit a factory in anywhere, even Logan, let alone overseas, to conduct an in-person inspection as to the conditions in which that factory is operated. It's never going to happen. We can pay for an auditor. You know, we could find a supplier, and the irony of that, right? Do some due diligence on the supplier, we get to do the due diligence on our suppliers. You know, we can do that, but even that is a real stretch of resourcing in an entity like UQ, and we're not alone in the Australian tertiary landscape. We have very defined budgetary envelopes. Universities don't like borrowing money to operate. You know, we every now and again will borrow some money to build, undertake a capital piece of work, but mostly we don't even like to borrow money to do that. So, we don't operate with an overdraft. We don't have that kind of financial management model. So where you've got a perfectly, like a very fixed envelope of resourcing, stretching it to these kind of potentially not esoteric to the person being impacted, but esoteric to the person sitting in their laboratory who wants they want the flask they want, and they really don't have time to think about how it's made. That's kind of my job, and I can do that, but that researcher doesn't want me to tell them which flask to buy either. So that is a fundamental problem in an environment like we're working in. The other complexity for universities is the context of our international partnerships and engagement strategies. They're very nuanced, but I don't think it's the case that any Australian university has stopped bringing in students from a jurisdiction that is a known environment for slavery practices. That hasn't happened to my knowledge. There's not appetite for that. And that's probably a two-edged sword, and that comes on to the reporting and mediation obligations in the Act, which are extremely onerous. And I would argue really, and you might have a different view, Antel, really poor public policy, because actually when you go and look at that, it is actually asking corporate citizens, whether they are private entities or whether they're a statutory body, but not government. If you really drill down, it is asking us to be the investigator. It is asking us to be the prosecutor. It is asking us to be the judicial decision maker. It is asking us to be the implementer of an appropriate rehabilitation regime. And it's also asking us to be the counsellor of the victim. And we just can't. It's just poor public policy, in my view. And I don't think about it nearly as much as any of the people on this panel. I have a bachelor degree from this university. So I think for something that is truly and deeply unethical, which is what modern slavery is, it's a crime to ask private entities to deal with the remediation of that crime, which is what the Act does ask. That's us actually asking us to be vigilantes. And I think that goes too far. I think there needs to be a balance between those things for this to be actually effective. So what I hope for, so this is the opportunity I think here is, so the federal budget, I think Erin might touch upon this, recently handed down includes funding for an anti-slavery commission. Absolutely applaud that development. What I sincerely hope is that the Commissioner doesn't focus on more compliance obligations, but rather recognises the power and the influence of government in this truly social imperative to deliver real outcomes for real people. We're trying to make an individual's life better. So whether they're in here in Australia or overseas, I think that is the real opportunity here. I think that corporation has a role to play, absolutely. But I really think without a true driver from government to undertake that, to take responsibility for the remediation piece, that's the only way there'll be true progress with this problem, because there's never going to be a thing I can't see from where I sit what a truly transparent supply chain could possibly look like, because I don't know where my tights are made.
Well, that is an absolutely wonderful illustration, Louise, of the immense challenges to actually preventing and remediating modern slavery in a real live organisation. And that's one that is in the public sector and is, you would assume, therefore motivated to do the right thing. So,
and sorry, that is absolutely our privilege. I work in an organisation that has these goals built into its strategic plan. You know, I have a mandate to do this work and it's hard.
Yeah.
You know, I have the privilege of being given some additional resources. I have to spread it across a few different social impacts, but, you know, I have extra resourcing for this. So I completely recognise how privileged we are. And that last piece, that reporting and mediation, I cannot see how I can do it.
and then that brings us to who else could play a part. And here we have the privilege of listening to Dr. Erin O'Brien, who's researching exactly this topic, the role that civil society actors play in identifying problems and suggesting improvements. You are researching this problem day to day, Erin. Please tell us more about their role, the civil society role, based on your research.
Yeah, sure. Thank you so much. And thank you for the opportunity to come and speak to you today. And I think there's, you know, the short answer to that question is that there are two different functions that civil society can serve. One of those functions is helping with a lot of the problems that Louise identified. So civil society organisations that are able to actually engage in some of the investigation and reporting that Louise is talking about. And I know the Australian Universities Procurement Network works with some of those organisations already, and really doing that work actually of engaging particularly with workers' organisations in all different countries, including Australia, where there are issues of modern slavery in our supply networks. The other function that civil society can serve is to, you know, this being a legal discussion today, and I confess I'm not a lawyer, but one of the functions they can serve is in trying to support actually the implementation of the legislation and serve a certain function as an accountability mechanism for disclosure regulations like the Modern Slavery Act. And it's that second part of the role civil society organisations can play that I've been researching, talking about today. And I think when you're talking about an issue like modern slavery, it is such a complex, multi-jurisdictional issue, as Antal was really emphasising, that it requires cooperation of a huge range of actors to actually address it. And it requires those actors to take their portion of responsibility for dealing with the problem. And I think a good place to start with this is recognising that modern slavery is an issue of structural injustice. You know, we have an economic system that is built around maximising profit, often as a result of labour exploitation. So it's important to recognise that modern slavery is not a case of a few bad apples. It's not a bug in the system. It is a feature of the system, a very shameful and embedded feature of our system. So to change the situation with modern slavery requires changing the system to a large extent and looking at the different responsibilities that actors have to actually achieve that. Often when we look at responsibility, we can take like a liability approach of who is to blame. That doesn't go far enough in modern slavery. We also need to ask the question, who benefits from the harms of modern slavery and who has the capacity to actually address this problem. And I think it's actually great that the focus has shifted away from governments alone and onto corporations to actually address this problem and to think about supply chains and consumption and investment systems that drive labour exploitation and how we can address this. So disclosure regulations like the Modern Slavery Act are designed to encourage corporations and public entities, sorry, shouldn't describe university as a corporation. Not yet, this is not recorded, is it? No, just kidding. So, you know, to get large institutions to look at what their responsibilities are, but disclosure regulations are very ineffectual without a strong accountability mechanism. And this is where civil society can really play a role. So when the Modern Slavery Act was introduced in Australia, the government was very explicit in saying that their expectation was that consumers and investors would essentially be the accountability mechanism, that they would punish and reward different companies for how well they were doing on addressing the issue of modern slavery. Now, of course, they can't do this by themselves. Consumers and investors need to be informed and they need to be mobilised to serve this function. And that's where civil society organisations can really play a role. And they can play a role by encouraging, for example, acts of ethical consumerism. So boycotts of companies that aren't doing particularly well, boycotts, or encouraging people to patronise particular brands or products. Or they can encourage and mobilise acts of political investorism. So shareholder activism through divestment, signing on to shareholder resolutions, or other forms of investorism like pressuring major institutional investors. And I'm thinking here specifically about superannuation funds, which are quite powerful in the Australian context. So in theory, consumers and investors are supposed to be able to serve as some form of accountability for the Modern Slavery Act. My research has been really about considering how that actually works in practice. And the short answer on that is that it doesn't. However, there is a role for civil society to play in putting pressure on and engaging through consumers and investors. So I'll talk a little bit about some of the ways in which this has been happening. In terms of consumer pressure, I've actually seen a couple of initiatives from civil society organisations in Australia that have been quite successful at this. So I'm thinking specifically about the Baptist World Aid Ethical Fashion Guide and Be Slavery Free's Chocolate Scorecard. Now, both of these initiatives actually predate the introduction of the Modern Slavery Act, but they now use the reports that are produced in compliance with the Modern Slavery Act to inform their methodology for how they rank companies on their performance on modern slavery. What's interesting with these, though, is that they haven't necessarily led to consumer boycotts, but they have led to improvement and engagement from companies on trying to address modern slavery in their supply networks. What's ended up happening really is that threat of the boycott rather than the boycott itself, and the possibility of negative media attention has encouraged particular actors to take a strong interest in trying to improve their score year to year. What's also happened, what my research has identified, is a little bit of an unintended consequence of consumer pressure in the area of modern slavery. Because what a lot of civil society organisations are saying is that companies are expressing some reluctance to actually adequately look for and report on instances of modern slavery in their supply networks because they are fearful of a consumer backlash or an investor backlash or negative media attention. And this is quite counterproductive because we know that modern slavery is in supply chains. If an institution is saying we don't have any, you haven't looked hard enough. To be honest, it is there. You need to look harder. Sorry, it's not your job. But we know it's there. And so having a consumer pressure system that to a certain extent is a disincentive for looking harder to find those instances and address them is a real problem. What we've seen then is that civil society organisations are actually pivoting their approach. They're moving away from a naming and shaming approach towards a naming and acknowledging or naming and faming approach, where they're identifying companies that are actually doing a good job. And one of the examples of this is a chocolate company called Tony's Chocolonely, which I apparently you can now get in Coles and Woolworths, who had instances of labour exploitation in their supply network, took action to address it. So they're trying to showcase examples of companies that have found it, that are dealing with it as a more positive, incentivising approach. My research has also found, though, that civil society organisations are saying that investors are really the more powerful actors in this space. And we've seen quite a couple of really key initiatives to try to use the power of investors to engage companies on these issues. In particular, the Investors Against Slavery and Trafficking Initiative, which is supported by the Walk Free Foundation, encourages and engages large institutional investors to engage directly with the companies that they're invested in and to share information and to collaborate on ways to address modern slavery in their supply chains. There are also more antagonistic approaches like shareholder resolutions against Coles, for instance, and also Centre Group more recently. So what we've seen is civil society actors are able to mobilise consumers and investors on this issue. It tends to be a little bit piecemeal. It tends to be actually about getting those companies that are more inclined to improve their performance. It does absolutely nothing for the laggards in this space. So unfortunately, while it's promising, it's not enough. And there's a really important role for stronger government regulation in this space.
Erin, it's hard to know where to start. There are so many people who are involved in making sure that modern slavery doesn't happen or it's addressed better. But I think the takeaway is there's some movements in the right direction, but it's really not nearly enough to try to turn the dial. And in fact, if you wanted to be cynical, you might just say that the regulations are a distraction from the fact that the system is directed to allowing modern slavery to happen as part of what we buy for the price that we get it at. We're happy to pay. Against that background, we turn to Thomas, who is a business ethicist. Thomas, it seems almost like the modern slavery regime is intended to activate business. So it's not just really a legal regime, but an invitation to the private sector to come to the party, to help and engage. So that brings us to the problem that legal and ethical expectations don't always align. When they diverge from each other, what can we do to address a problem like modern slavery?
Thanks, Radha. That's, I think, a good segue. I'm not sure I have much to add, actually. It was so comprehensive for the perspective of the panel here. But as you say, I mean, my background is in business ethics. And so I've been in the field for, some 30 odd years. And I'm old enough to remember the promise of globalization, right? It was 25 years ago, more or less, the late 90s. And the promise was, we all get more freedom, markets would produce freedom, and everyone would be better off. That obviously hasn't occurred. Otherwise, we wouldn't be sitting here and talking about modern slavery. You mentioned the numbers in your introductory statement. So 50 million people are in modern slavery, a big part of which is forced marriage. But, we're talking about forced labor. 3-point-some million children, which is outrageous. So the question is, what has gone wrong in terms of the global system? And comes back to the point Erin made earlier, that it's sort of a structural issue that we have. It's a profitable business. The market is $200 billion. That's the modern slavery market. And that's how it works. It is 30 times more profitable to have a slave today than it was 200 years ago, which was, we look back and see, the heydays of slavery, right? 1810, 1820, where this was big business as well. But it's so profoundly profitable that something seems to be completely wrong. And the problem is, unless we address it structurally, unless we address it from a systems perspective, not much will change. And corporations do play and have to play a very active role in this. So I applaud the efforts with the Modern Slavery Act, but I don't think it's a sufficient condition to actually address the issues arising from modern slavery, because much of it is structural. There's something wrong with the system in the sense that, if we continue to think about profit maximization, that was mentioned earlier, there will always be trade-offs, and there will always be people looking for loopholes in the system to actually benefit from that system. And of course, digital technology as well as globalization as such in terms of logistics behind globalization. You know, it's everything was meant to be seamless, and it almost is, but it also meant that it's much easier these days to, you know, transport slaves than it was 200 years ago. So that's a big part, I think, of the problem, and that's something we have to keep in mind. But, you know, as an ethicist, I feel outrage as to what is going on. And I think what is required is substantive action. And substantive action by some of the key players. So governance do play a very active role. We heard about the different national initiatives, and that's all well and good and well intended, and it's an important factor, but it's a minimal condition. So we have to actually get corporations who are the biggest actors, you know. More than 60% of the largest economies in the world are corporations, not nation states. You know, it's a huge number, and it's sometimes, you know, the Walmarts and so on, the Amazons of this world. And some people, leaders in this, have, you know, huge power, mass power. You know, you talked about fashion earlier. You look at the fashion industry, Ortega, you know, the guy behind Zara and Inditex. I mean, he's among the top 20 richest men in the world. And we don't, I mean, they have an interesting system, you know, they're still produced in Europe, actually, you know, here now and then, but, you know, it's, if we get people in the fashion industry to pull in the same direction, it could be a game changer. But it's a long way to go. The price for a T-shirt 30 years ago was around $12 on average. So, you know, let's say $18. You know what the price is today? $12, $18. You know, if you fill up your car, it's a bit of a different price shocker. That was very different 30 years ago. So again, that's a reflection, I think, of the systemic issues we face, because if you buy a, you know, $10 T-shirt, $5 T-shirt, you have to factor in, and that's exactly what you said, that something's not quite right. And so consumers are also part of this. But let me focus on the role of cooperation. I think we don't do enough about it. So in that sense, I think from an ethics point of view, I would argue that modern slavery is an ethical tragedy, because we know we need to do more, but so far we don't. Yes, you have the Modern Slavery Act, but we don't do enough. Similar climate change. And, you know, it's also an ethical tragedy. We know we have to do more, we don't. So what about the role and responsibility then of corporations? I want to sort of perhaps approach this through three different lenses very briefly. Justice, I'm not a legal scholar, so this is my layman's perspective. Ethics and agency. If we look at it from a justice perspective, so I think there's one element there that actually could very much help to fix the problem, and that would be to look at corporations as agents of justice. It's not a very popular view, but if we think, for example, in terms of Young's, an American philosopher, social connection theory of justice, then we can realize that, you know, corporations are part of a broader network. They're engaging with stakeholders, engaging with the global economy, and in doing so, they are connected, you know, connect to stakeholders, they work through these connections. And so while there is no global regulation around modern slavery, while there's no global law, they still act as agents of justice. They have actually the power to make a difference. Corporations often shy away from that view because they don't want to be seen as political, when they are. In fact, you know, they all lobby, they all engage with politics. But at that global level, I think that's a very important factor. So let's look at this as corporations, as agents of justice, and what they can do to actually remediate the problem of global slavery. That means, you know, addressing the issues in the supply chain. You want to have integrity in the supply chain, you actually have to change the way you produce. So the specific set of responsibilities that emerges from it. From an ethics point of view, from an ethics perspective, I think, you know, we have obviously the problem that we don't have global standards of common decency, dignity, and recognition. Yes, we have the human rights agenda, but we don't have those standards. So again, we have to rely on corporations to act with decency in regards to their stakeholder. That means they have a specific responsibility to actually engage in the fight against modern slavery. It means thinking about moral possibilities beyond law, thinking in terms of systems of self-governance, of self-imposed guardrails, self-binding measures, much as like Ulysses in Homer's history. These are simple but very effective measures to say, look, I don't want, how much profit is enough? There's a great sequence in one of the Michael Moore movies, when he asked Phil Knight, the founder of Nike, well, you're a billionaire. Would it be okay to be half a billionaire? And Phil Knight has no answer. He's completely dumbfounded by that question. But it is a relevant question. How much is enough, right? And so if we rephrase and reframe profit maximization as something different and start to change that, then the role of guardrails, the role of taming yourself and setting yourself boundaries is a really important one. And corporations say, oh, if I do that, I lose out because competition will move in. Well, then do it as an industry. Right? So I think that's a really important factor. And the third point, and I come to a close, I got the timing, is around agency. And that means that we need to have business leaders to actually have a globally responsible mindset. And that means we have to educate them accordingly. So universities do play a key role, business schools, but also corporations have to actually make sure that their leaders are embracing their shared responsibility, their shared agency. They have a political core responsibility for the state of the world in which they operate. And again, it's a contested space because most businesses and leaders shy away from that political responsibility, but it is a very important one. So, in closing, I think there are three core duties for businesses: the duty to assist as agents of justice, the duty to advance human dignity, and the duty to engage in proactive ways to end modern slavery. Thank you.
Thank you for joining me in thanking our panelists initially for these wonderful presentations. I think what we have here is, as Thomas said, a message that governments need to do more to give people within organisations the leverage to do more to help people outside those organisations, be they people who are going to hold those organisations to account or the people who are actually affected by modern slavery.